Okay, let's dive in. Picture this. A quiet suburban night in Sydney. Suddenly just shattered. Pure terror. A violent home invasion.
Yeah, imagine the chaos, the fear for the family inside.
And right in the middle of it all, this single crucial moment. A masked intruder. There's a struggle. The mask gets ripped off.
And the victim instantly recognizes the face underneath. Chilling. You'd think, okay, that's it. Case closed almost.
You would think so. But as anyone who follows the law knows, what happens in court is, well, it's a whole different world, isn't it? An arrest is just the start.
Oh, absolutely. Then you get into the defense, the prosecution, challenging evidence, building narratives. It's complex.
Exactly. And in this particular story, the brutal crime and the sort of strategic legal defense world, they didn't just run parallel. Years later, they collided hard.
And not how you might expect, like during the trial itself.
No. It was because of the secret recording, a hidden conversation that completely blew up a court-presented alibi. And it ended the career of a pretty well-known, successful barrister.
Right. So that's what we're doing in this deep dive. We've got this stack of sources, court judgments, tribunal decisions, articles dissecting the case.
Yeah, and our mission for you, our listener, is to pull out the key insights, piece together this incredible, true legal crime story.
And it really is a cautionary tale, a powerful one, especially if you're thinking about a law career, or maybe you're already in it.
Definitely. This deep dive is all about that. We're focusing on the down firm of Barrister John Patrick Punch, how this chance recording exposed a false alibi he presented.
And what the whole saga tells us about those ethical lines, the ones lawyers just cannot cross. Ever.
We want you to get the whole picture, quickly but thoroughly. The surprising facts, the big implications.
Okay, so before we get into the timeline of events, maybe we should introduce the key players, sort of set the stage.
Good idea. Let's look at the dramatis persona.
Right at the center, the man whose career basically imploded is John Patrick Punch, often called Johnny Punch.
The sources paint him as, a really seasoned SETI defense barrister, admitted way back in 1984.
So, decades of experience, known figure, charismatic, confident, got the tough cases.
Exactly. Busy practice, solid reputation for over 20 years, until this ethical lapse from years before finally surfaced. And his conduct ended up under this incredibly intense scrutiny.
Then there's his client in the original case, Tony Haddad, a young man accused of that armed robbery we mentioned.
In court, he stood up, swore he was innocent, had this detailed alibi backed by witnesses.
But that secret tape, it captured a whispered admission that told a very, very different story about where he actually was.
And alongside Haddad was Joseph Joe Truglia. He was the co-accused in the robbery.
And crucially, he was also in the police cell during that critical conversation with Punch and Haddad.
Yeah, the sources mentioned that later on, when the truth about the alibi came out, especially around perjury charges, Truglia's path, his outcome, was different from Haddad's.
Okay, now, a really key figure for the prosecution right from the start was Effie Mandadakis.
She was one of the victims in the house during the robbery. Her testimony was absolutely pivotal.
Because she was the one who provided that key eyewitness identification. She said she confronted an intruder, pulled his mask off, and instantly recognized Tony Haddad.
That's incredibly damning evidence, isn't it? Instant recognition. That's tough for a defense lawyer to counter.
Oh, huge challenge. Probably the main obstacle for the defense in that trial.
So, to fight that, the defense strategy heavily relied on the alibi witnesses.
Right. There were 4 of them, friends and family of Tony Haddad. Let's see, the sources named Christine Condos, who's described as his girlfriend at the time.
And Ahmad Farhat, Nabil Haddad, and Shura Haddad, family members, friends.
And they all got up in court under oath and swore that Tony Haddad was with them at his family's place in Punch Bowl, miles away from the robbery scene in Roselands.
Their testimony was designed to create this, rock-solid picture that he couldn't possibly have been at the robbery, directly contradicting Effie Mandadakis.
And that testimony, their sworn evidence, that became the absolute focus of the misconduct case against Punch later on.
The judge who heard that original armed robbery trial was Judge Nash, DCJ, District Court Judge.
And it was a judge-alone trial, no jury. So Judge Nash had the sole job of weighing everything, Mandadakis' identification, the alibi, everything.
His decision to acquit Haddad and why he acquitted him, that's really central to understanding the whole Punch situation later.
Right. Now, the thing that really triggered the disciplinary case wasn't anything from the trial itself. It was something that happened before the trial.
Captured by NSW police investigators. But here's the twist. They weren't investigating the robbery at all.
No, they were detectives on a completely separate case, the murder of a man named Andre Rom back in November '94.
And as part of that murder investigation, they got a warrant to put a listening device, a bug, in a cell at Bankstown Police Station.
And just by pure chance, that bug picked up the conversation between Punch, Haddad, and Treglia talking about the armed robbery defense.
Totally accidental capture. But that recording became the absolute linchpin, the crucial evidence in the disciplinary case against Punch years down the track.
Okay, so fast forward years later. The disciplinary action gets started. The body bringing the action is the NSW Bar Association. They're the ones who regulate barristers.
And representing them, prosecuting the case against Punch, was a very senior, very respected barrister, Stephen Odgers, SC.
Yeah, a formidable senior counsel. His job was basically to prosecute one of his own alleging serious professional misconduct. A tough job, but necessary for upholding standards.
And a defending Punch through all of this, the disciplinary hearings, the appeals, was another veteran senior counsel, David Fagan, SC.
Also a tough job. Defending a colleague against allegations about conduct from, over 10 years earlier? Trying to save his professional life.
The main disciplinary hearing itself happened before the Administrative Decisions Tribunal, the ADT.
And the specific panel hearing this really serious case had 3 members, Deputy President Ann Carpin, AADCJ, who was an acting district court judge.
Mr. Roberts, LPQC, a judicial member, and Ms. Hayes, a lay member. They had the heavy task of deciding if Punch committed misconduct and what should happen.
And finally, there were legal arguments, especially about whether that secret tape could even be used. Those arguments went all the way up to the NSW Court of Appeal.
Right, the state's highest court. Judges there, including Mason P., Tobias J.A., and Bell J., they made some really important rulings on evidence in disciplinary cases. Set a big precedent.
Phew. Okay, so that's our cast. Quite a few players involved over the years.
Yeah, it sets the scene. So let's rewind now. Go back to the start. The crime itself and that first trial.
Right. November 18th, 1994. Roseland, Sydney. This violent armed robbery, a home invasion, sources say was terrifying for the Mandadakis family.
And that key moment we keep coming back to. Effie Mandadakis confronting an intruder, pulling off his mask.
And her immediate stated instant recognition of Tony Haddad. That's powerful stuff for a prosecution case.
So Haddad and Treglia get arrested just a few days later, late November '94, charged with armed robbery, assault.
And this is when John Patrick Punch gets hired by Haddad. He receives the police brief, all the evidence the police have gathered.
Including, crucially, Effie Mandadakis' statement. Punch, being an experienced barrister, he'd know straight away, okay, this identification is the big hurdle.
Definitely. Eyewitness ID, especially from a victim saying instant recognition, that carries a lot of weight.
The trial happens fairly quickly, June 1995. Judge Nash, no jury.
So Punch's job is clear. He needs to counteract that identification evidence. You know, the standard defense approach is to question it. The lighting, the stress, the procedure.
Right. But often, an even stronger tactic is an alibi. Positive evidence showing your client was somewhere else entirely.
And that's exactly what Punch did. He leaned heavily on the alibi. Haddad himself testified, denied being there. The sources quote him saying he'd never been to the Roselands house in his life.
And then came the 4 backup witnesses. His girlfriend, family members, all swearing under oath he was with them in Punch Bowl that night.
It was presented as this solid block of evidence. Consistent, detailed, multiple people saying the same thing, all questioned by Punch. The strategy was clear. Create reasonable doubt. Make the judge think, well, maybe the identification was wrong because look at all these people saying he was elsewhere.
And on the surface, it worked. July 1995, Judge Nash acquits Tony Haddad.
But the judge's reasoning is key here. The sources say he was persuaded by the preponderance of alibi evidence, the sheer weight of it.
It's interesting, though. Judge Nash apparently said he didn't disbelieve the victims, the Mandadakis sisters. He found them credible.
Exactly. But faced with Haddad and 4 other people swearing he was somewhere else, the judge felt he couldn't be sure beyond reasonable doubt. The alibi did its job. It created the doubt needed for acquittal.
So, looks like a win for Haddad, a win for Punch. The defense strategy seemed to work perfectly.
Seemed to, but nobody in that courtroom knew about the conversation recorded months earlier. The one that could tear that whole defense apart.
Okay, so this is where it gets really interesting. Secret recording. Let's flash back.
Right. Back to December 1994. Haddad and Treglia have been arrested. Punch has the police brief. He knows about the identification. He goes to meet them in the cells at Bankstown Police Station. Standard procedure. discuss the case, the defense.
But here's that incredible twist. That cell, it was bugged.
By totally different police. Detectives investigating the Andre Rahm murder, which had happened the month before. Nothing to do with the robbery.
They'd gotten a proper warrant for the listening device under the Listening Devices Act, granted December 13th, 1994, by a judge.
And the sources are clear. The police affidavit to get the warrant specifically said they were investigating the murder and not trying to get info on the armed robbery charges. It was a lawful warrant, but for a totally different purpose.
But bugs don't care what you're talking about, do they? So December 14th, 1994, it records Punch, Haddad, and Treglia talking about the armed robbery case.
And this is where the absolute document evidence comes from. The smoking gun, if you like.
The transcript, which the disciplinary tribunal later examined closely, captures this exchange. Haddad says something. Then, crucially, talking about the robbery, he says, because I was in the back room like I was telling you.
I was in the back room. An admission he was there, at the scene.
And Punch's reply, caught on tape, shows he understood the implication. He says, you were out the back, but you're still guilty, if they can prove that.
Wow. So the tribunal later looked at this very carefully. They interpreted Haddad saying, I was in the back room, as a confession. Maybe not to being the main robber, but definitely admitting presence, involvement, an accessory maybe.
When they found, Punch's response showed he got it. He understood it as an admission of guilt or at least involvement. The sources say the tribunal noted he accepted the statement without demur, without argument or surprise.
Which suggests maybe it wasn't the first time he'd heard something like this from Haddad.
And that recorded moment right there highlights this massive ethical crossroads for a lawyer. What do? Your client confesses guilt privately, but wants to plead not guilty in court.
It's probably one of the toughest spots a defense lawyer can be in, but the rules are actually very clear on this. It's not a gray area.
In NSW, it's governed by the barrister's rules, specifically Rule 33. Every barrister learns this.
Rule 33 basically says if your client confesses guilt but insists on pleading not guilty, you've got limited choices.
Option 1, if there's time for them to get another lawyer, and they don't insist you say, you can and probably should return the brief, withdraw.
Right. But, and this is the critical bit for Punch, if you do stay on the case, your options in court are really restricted.
You absolutely cannot falsely suggest someone else did it. Can't point the finger elsewhere if your client told you they did it.
And crucially for this case, you cannot set up an affirmative case inconsistent with the confession. Meaning you can't build a positive story that contradicts what your client admitted. You can't run an alibi saying, my client was miles away if they told you I was in the back room. That's actively misleading the court.
So what can you do if you stay on?
You can still test the prosecution's case. Argue the evidence they've presented doesn't prove guilt beyond reasonable doubt. Poke holes in their argument.
You can argue legal points, maybe why they aren't guilty in law, even if they were involved factually.
Exactly. But the line is bright and clear. Challenge the prosecution's proof. Yes. Actively put forward a false narrative or evidence, or believe is untrue based on the confession. Absolutely not.
And that was the core allegation against Punch. The Bar Association said he heard Haddad's admission, I was in the back room.
Understood it as a confession of presence.
Stayed on the case.
And then, at trial, didn't just attack the identification evidence, he went further. He actively presented the alibi. Had Haddad and 4 others testify that Haddad was in Punch Bowl.
Directly contradicting the confession. Setting up that affirmative case, Rule 33 forbids. Leading evidence he knew, or at least strongly believed, was false.
Exactly. That was the heart of the professional misconduct charge.
And that tape just sat there for years in police files.
Although the information wasn't totally buried, the sources mention Haddad and Treglia were eventually charged with perjury over that 1995 alibi evidence, and Treglia actually pleaded guilty to perjury in 2001.
So authorities knew the alibi was fake, and the tape was likely part of that knowledge well before the Bar Association got involved with Punch.
Right. But it took nearly a decade after the trial for that recording to land on the NSW Bar Association's desk. We don't know exactly how it surfaced for them.
But when it did, they realized its significance regarding Punch's conduct.
So in 2004, they formally opened a file, started disciplinary proceedings. They went to the Administrative Decisions Tribunal, seeking the ultimate sanction, striking him off the role of legal practitioners. Disbarment.
The charge was simple but devastating. Punch led evidence from 5 witnesses in the 1995 trial knowing it was untrue, a fundamental breach of his duty to the court.
Punch's side, represented by Mr. Fagan SC, raised the obvious points. Look, this was over 10 years ago. He's practiced without issue since then. An old, isolated incident shouldn't end his career now.
But the Bar Association's view, and ultimately the tribunal's, was that misleading the court is so serious, so fundamental, that time doesn't just wipe it away. Public protection and the integrity of the justice system had to come first.
Before they could even argue about whether Punch knew the alibi was false, though, they had this huge preliminary fight. Was that secret tape even allowed as evidence in the disciplinary case?
Yeah, this was critical. If the tape was out, the Bar Association's case against Punch would be much, much harder to prove.
Punch's counsel, David Fagan SC, argued passionately against it. He said it was obtained unlawfully or improperly, essentially.
His point was, the warrant was for the murder investigation, not the robbery. The police themselves said they weren't looking for robbery info.
So, using this accidentally captured conversation in a totally different context, years later in a civil disciplinary hearing, Fagan argued that violates the spirit of the Listening Devices Act, undermines lawyer-client confidentiality.
He pointed to Section 14 of the Act, which did explicitly allow inadvertently obtained recordings in criminal cases, but said nothing about disciplinary ones. He argued that silence meant it was prohibited, an implied ban.
And even if technically lawful, he argued the way it was obtained and used was improper, so the tribunal should use its discretion to exclude it, like under Section 138 of the Evidence Act principles.
But the Bar Association, through Stephen Odgers SC, pushed back hard. They argued the ADT isn't a criminal court. Its main job is finding the truth for public protection.
Odgers argued that the recording was made lawfully, under a valid warrant. The fact the relevant conversation was accidental didn't make the recording illegal.
He tackled the Section 14 argument head-on. He said the Act only banned using evidence obtained in contravention of the Act. This wasn't.
And silence about civil or disciplinary use didn't mean prohibition, he argued. What's not forbidden is permitted, especially for a body overseeing professional standards. Plus, you had the underlying context, a lawyer potentially facilitating a fraud on the court.
In June 2006, the ADT panel, led by Deputy President Carpin, made their ruling. They sided with the Bar Association. The tape was in.
Their reasoning followed the bar's arguments. Lawfully obtained recording. Section 13 didn't apply because it wasn't made in contravention of the Act. Section 14's silence wasn't an implied ban. The evidence wasn't improperly obtained in a way that demanded exclusion here.
Big win for the Bar Association. But Punch didn't leave it there. He appealed this ruling to the NSW Court of Appeal.
This appeal was important beyond just Punch's case. It would clarify the rules for using this kind of evidence in disciplinary matters generally.
April 2007, the Court of Appeal Mason P., Tobias J.A., Bill J. gave their judgment. They upheld the ADT's decision. The tape was admissible.
They specifically agreed that Section 14 of the Listening Devices Act does not implicitly ban using lawfully obtained recordings in civil or disciplinary proceedings, a major clarification.
So the legal fight over the tape was over. The Bar Association could use it. Now the case moved to the main event. Did Punch know the alibi was false?
Right. The substantive hearing at the ADT happened in October 2007, with the decision in March 2008. The focus now. Punch's state of mind back in 1995.
The key evidence. That recording from December 1994, audio and transcript. And the sources say the tribunal actually watched the video recording, too.
Yeah, they said seeing the interaction helped them understand the exchange. Haddad's confession, Punch's reaction, added weight to their interpretation.
And faced with this, Punch made a critical choice. He attended the hearing, but he did not testify. He remained silent.
His lawyer tried to offer a possible explanation. Maybe Haddad changed his instructions after the tape was made but before the trial. Maybe he explained away the backroom comment.
But it was just speculation. There was zero evidence presented to support any change of instructions.
And Punch's silence, that became incredibly significant. The tribunal applied this principle, mentioned in the Meeks case. When a lawyer faces misconduct allegations about something uniquely within their own knowledge, like their state of mind, and they don't testify,
the tribunal can draw an adverse inference. Not as punishment, but as common sense. Why wouldn't you explain yourself if you had a good explanation?
Exactly. The inference was that Punch didn't testify because the truth wouldn't have helped him. It likely would have confirmed he knew the alibi was false.
So, putting it all together, the tape showing the confession and Punch's reaction, the lack of any other explanation, the adverse inference from his silence.
The tribunal was comfortably satisfied, to the required Brigham-Shaw standard, that Punch knew the alibi evidence he led from Haddad and the others in June 1995 was untrue. He knew it when he presented it. His belief, formed from that confession in December '94, hadn't changed.
And once they found he knew it was untrue, the finding of professional misconduct was basically automatic. Leading false evidence, that's a cardinal sin for a lawyer, a direct breach of Rule 33.
A very grave finding, which led directly to the question of penalty.
May 2008, the penalty hearing. The Bar Association asked for the maximum removal from the role, disbarment. They argued he just wasn't fit to be a barrister anymore.
And the tribunal agreed. They ordered him struck off. Their reasoning was powerful.
Firstly, the sheer gravity of the misconduct, deliberately misleading the court. That strikes at the absolute core of justice. They said it inevitably leads to a finding of the most serious professional misconduct.
Secondly, his behavior during the disciplinary process. He offered no explanation for his actions back then, no acknowledgement of wrongdoing, no remorse shown.
And critically, no evidence of rehabilitation. Nothing to show he'd changed in the 13 years since.
So the tribunal concluded. His actions in 1995 showed he lacked the essential character and trustworthiness needed. And with zero evidence of change since then, they couldn't be satisfied he was fit to practice now.
Protecting the public, maintaining the profession's reputation, those were paramount.
The order was immediate. Career over. More than 2 decades of practice gone because of that ethical failure exposed years later.
The impact of this case was huge in the legal world, wasn't it? A real shockwave.
Oh, definitely. Strikeoffs happen, but for this specific reason, knowingly misleading the court with a false alibi confirmed by a secret recording that's pretty rare and very significant.
It really hammered home those core ethical principles.
Absolutely. Number 1, duty to the court comes first, before the client. Always. Honesty and candor are non-negotiable. You can't lie for your client. Punch's case is the ultimate example of getting that balance wrong.
And it made Rule 33 incredibly real. If your client confesses, your options are limited. Test the prosecution evidence, yes. Construct a false story, never. Withdraw if you have to.
It became, like you said, a textbook case study in legal ethics classes. This is what not to do. The price of winning through deceit is just too high.
And that Court of Appeal ruling on the tape's admissibility set a legal precedent too, right?
Yeah, clarifying that lawfully obtained surveillance evidence, even if accidental regarding this specific conversation, can be used in disciplinary proceedings. Lawyers can't just hide behind technical criminal evidence rules to avoid professional accountability.
The sources mentioned some chatter about why Punch wasn't criminally charged with perjury or perverting the course of justice.
Yeah, some criticism perhaps. Reasons aren't clear. Maybe evidentiary issues for a criminal standard. Maybe a choice to focus on the disciplinary route given the time lapse. But being struck off is still a massive career-ending penalty.
It also shows the system can reach back, even over a decade later, for serious misconduct. Staleness wasn't a barrier here because the conduct was so bad.
In the end, accountability was achieved, even if the original acquittal stood. The lawyer who facilitated the false alibi was held responsible.
So the big takeaway, especially for our listeners maybe thinking about law, duty to the court, duty to the truth, it's everything. No win is worth sacrificing that.
You just have to picture that scene. Punch, silent in the tribunal, his career ending, all stemming back to that voice on a tape recorder years earlier, confirming he knew.
It's a gripping story, a real legal drama, but definitely not one any lawyer wants to star in.
Absolutely not. The cost of compromising your integrity is just devastating.
Which leaves us with a final thought for you to chew on. The whole legal system relies on people being basically honest, right? Lawyers, witnesses. So what happens when that breaks down?
And how does society make sure that when someone does break that trust so badly, accountability eventually finds its way into the open, onto the record, no matter how long it takes?
The story of John Patrick Punch, in its own way, shows that sometimes the truth does come out, eventually.